To the court, I'll call the case.
All right, thank you. We are live and recording. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. Welcome to the December 1st, 2021 sitting of the Massachusetts Appeals Court. I'll introduce the panel. I am Justice Eric Nyman. Sitting with me today are Justices Kenneth Desmond and Justice Rachel Hirschfang. Our first case today is Commonwealth versus Reed, 2020 P1176. We will hear first from counsel for the appellant, and that would be Attorney Oswald.
If it pleases the court. Ladies and gentlemen of the court, Mr. Reed is asking that you all suppress the evidence that was obtained as a result of the illegal entry into his residence. The justification for that is because the police lacked reasonable belief as applied to a rooming house with multiple bedrooms. It's talking 4 bedrooms on the basement floor of that rooming house. Reasonable belief, as Your Honor is aware, requires that the police have a reasonable belief that the location to be searched is the arrestee's residence, and also that the arrestee is in their residence at the time the police enter to make the arrest. And in the context of a rooming house.
So Mr. Oswald, couple questions. First, so what you're trying to suppress are the photographs and the bloody tissues, is that correct?
To suppress everything that was obtained as a result of
What do you say that is?
I would say that that's not only the bloody pillows, the paper towel, the blood stain on the bed. It's the imagery of what the officers observed when they walked in there. So it wouldn't not only would it be, and the Commonwealth kind of points this out when they talk about the photographs of the scene. It would just be that imagery and the imagery that goes along with this imagery of the defendant seemingly hiding in the closet. So I would ask that everything that was obtained there would be suppressed.
Okay, and do you agree that Commonwealth v. Silva pretty much governs the outcome of this case in many respects?
I do believe that for the most part, Your Honor, yes. I think that Commonwealth versus Gentile has a lot to say about it in terms of informing the discussion on the case, but I do agree that Commonwealth versus Silva does govern the outcome largely.
And let me ask you this, if the basement apartment had been his apartment, but he had roommates, would the police have been able to look in the other bedrooms?
I don't believe so, Your Honor, no.
Okay.
Well, I guess when we talk about the basement apartment, the testimony at the motion to suppress made clear that there were 4 bedrooms in the basement apartment. So
I understand.
I don't know if we could break it up to mean, hey, I don't know there's any evidence that says the basement unit as a whole was considered an apartment or that each room within was considered a separate apartment.
I understand, but I think I read in the hearing, in the transcripts, that the police, at least one of them, believed that it was a single apartment in the basement at first. And so my only question is, assuming that it was a single apartment and it had 4 bedrooms, would he have been able to look in the 4 bedrooms?
No.
That's your position?
That's my position, Your Honor, because there wasn't a reasonable belief as to a specific room, or apartment room within those bedrooms.
Need it be that specific? Can it be just that reasonable belief that he was home?
Well, I think if we follow that line, then we would have to say if this was a Holiday Inn Express and we were looking at the 3rd floor of that and we heard, hey, he's staying in the 3rd floor, then the police would be justified to enter each and every room of that hotel floor, because that's essentially what we're talking about here. We're just talking about essentially, a less legal sort of hotel in a lot of ways. I don't know if there's any evidence that wasn't a legal rooming house, but in essence, this is essentially a hotel that we're talking about. Temporary stay or stay for.
I'm sorry to interrupt you, but let's assume that the other rooms were not this defendant's apartment. Will the defendant have standing to contest the police entering other apartments for which he wasn't a resident, had no ownership?
No, I don't believe so. I don't think that there's a privacy interest that's implicated in that sort of analysis. But here, his apartment was entered, and that's what we're challenging.
Let me ask you. I'm sorry. Go ahead, Justice Hirschfeld.
Okay. No, go ahead. You're still going.
Two questions by way of background. The first one is, I didn't see in the record appendix, and I may just be missing it, I didn't see the motion to suppress and the supporting documents. Was that filed as part of the record appendix? I know you weren't a motion counsel, but I didn't see it.
Off the top of my head, I'm not exactly sure, Your Honor. I failed to review that before we came in here today. I don't know, to be sure.
Because without that, I'm wondering, how we know what specifically was raised in the motion itself.
I think we have, largely what was there by way of oral argument in the record. I don't know. I'm sorry that I don't know.
Okay.
But I don't know the answer to that right now.
And that leads to my next question, which is, in your brief, you mentioned that the judge made oral findings of fact and rulings of law. And I didn't see any findings of fact, actually. I saw the judge indicate in the transcript that the motion was denied, but I didn't see her make any contemporaneous findings of fact.
That was an error on my part. That was kind of stock language that I should have examined before I put it in the brief as well. Counsel pointed out in his brief that exactly what Your Honor indicated in one of his footnotes to his brief, that there wasn't written findings or oral findings, really.
So I gather neither you nor predecessor counsel filed a motion asking the motion judge to issue written findings of fact and rulings of law?
No, Your Honor.
Okay, so with that in mind, then I'm proceeding under the assumption then that your argument is that accepting all of the officers, all of the testimony presented by the Commonwealth as credible and true, there still was not a reasonable basis in your view to allow the officers to effectuate the arrest warrant at that particular apartment. Is that correct?
That's correct, Your Honor. Okay. I don't think that it's the showing here in terms of the evidentiary support for their reasonable belief was sufficiently strong to justify the invasion under Commonwealth versus Gentile. I don't think that it was sufficiently there. I think there was a lot of innuendo, as counsel kind of pointed out, but I don't think we can make assumptions about what the police knew, when they went to that address. We have to go on the facts that were testified to.
Okay, Justice Hirschfeld?
I can't remember my earlier question, but maybe I'll come up with another one. So I just want to kind of trace out, if I can, for my own thinking, where sort of the point at which you are arguing what the officers were doing became unlawful. So they're in the building on a higher floor. Based on the information that they had at the time. If I understand correctly, you're not contesting their ability to be there. Am I right about that?
You're correct, Your Honor. It appears that somebody with at least apparent authority allowed them into the residence.
And then they are told where the entry to the basement is, and they see the stairs down to the basement. And if memory serves, it's actually quite a while before they take those stairs down, during which they're hearing these rustling noises and the music going up and down and all of that. Is your contention that based on the information that they had at the time, they were not permitted to go down those stairs to the basement?
Well, I think the fact that they took such hesitation at the top of those stairs made it quite clear they didn't know what was down there, in terms of they didn't know whether it was one apartment, they didn't know whether it was multiple apartments, and they had even indicated such with the state trooper's concern with the canine unit, that he didn't let the canine loose because he didn't know whether there were other tenants down there. So I think that kind of tells us about what they had in terms of a reasonable belief, and that reasonable belief, it was, hey, we really don't know what's going on down here. We don't know whether it's one apartment with one person in it. We don't know whether it's 4 apartments. We just don't know.
So.
And so is
reasonable-
it oh, sorry.
I'm sorry, I didn't hear the
so-
answer to the question though. Are you saying they couldn't go down the stairs or not?
I don't believe they could.
So your position is that they were stuck at the top of those stairs, that they couldn't get down there based on the information they had and the observations that they were making continuously while they were on the scene.
You know, I should clarify, or I should restate what I mean. I think that they could go down there, as long as there's not something that the lack of factual specificity as to what they saw at the top of the stairs and whether they could see that there were multiple rooms down there, whether this was a common hallway. I think that kind of informs what we're looking at here. If they had looked down there and they saw multiple rooms, multiple bedrooms, and you know, they were able to see that, then I think they could go down there and you know, see if the doors were numbered, and then they could kind of do a further analysis at that point. But we just don't know a lot about what was down there. So I think they could have probably walked down there since they were allowed in, but there's just not enough in terms of a factual showing in the appellant's position.
All right, so when they go down.
So my memory, but my memory is, sorry, on that point you just raised, that I think the record actually is pretty clear that from the top of the stairs, they couldn't see, right? There was a bend in the stairs and they couldn't see around the wall. So are you saying now that they were allowed to go down there and see what was around the bend?
All right, and that's my mistake as to that particular fact. I lost track of that one.
Well, it may be my mistake. I wouldn't be so sure.
No, I'm sorry. I think Your Honor is correct. I do remember that as I was reviewing again. I don't think that they could go down there because they don't know the layout of what's down there, and they admitted as much. And they were concerned for going down there. They were concerned for having, you know, this canine officer go down there. They were, because they didn't know. They had a concern that there were other tenants down there. So I don't think that they could go down there.
All right, so they were in a common hallway, right?
At the top of the stairs, I believe so.
Right, and the stairs that led down to the basement, that was an extension of the common hallway. They hadn't entered any rooms by going down the stairs, correct?
Right.
Okay, and it's 2 o'clock in the morning.
Right, 2:30, I believe.
They know he lives in the basement, or they have reasonable belief that he lives in the basement. That's why they go and they ask, "Where's the basement?"
Don't know that there was testimony to the effect that he lived in the basement.
Well, they got there and they asked, "How do you get to the basement?" Why did they ask that question?
That's a great question that we should have had the information solicited by the Commonwealth at the motion to suppress.
Can't we infer that they knew it was the basement because they had the victim who was kind of communicating with them from the hospital?
We don't know what she said to them in regard to that, and we can't just say, well, because they went to the basement, that must have been what she said.
They asked specifically about the basement. When they got to the front door, they asked the tenant who let them in, "Where's the basement?" So can't we infer that they were searching for him in the basement?
We can infer that they were searching for him in the basement, but we can't infer that the officers had information without testimony, without some fact elicited at the motion to suppress hearing in regard to that. We can't just make a jump in terms of creating a fact and out of whole cloth. No, Your Honor.
What else do you think?
Well, Your Honor, I just think Mr. Reed is just asking the court not to erase the firm line that the Fourth Amendment and the 14th Amendment, or Article 14, have drawn at the entrance of the home. If this sort of search is permitted, this sort of entry is permitted, then we have a situation where, you know, the Commonwealth isn't going to say it, but we're having a situation where if someone says so-and-so is on the 3rd floor of a hotel, you can just go willy-nilly through every apartment in there. Mr. Reed, Mr. Reed's position is that, he is innocent of these charges. He would be asking that your honors would order a new trial here, a vacature and reversal of the court's order, remand to the trial court for a new trial, give him the opportunity to proceed, present the defense that he wanted to present on the day of trial. But what was allowed into evidence here, and our position erroneously prevented him from bringing that defense forward. And that's part of this, right? But just in terms of presenting Mr. Reed's case, that is what I'm asking your honors to do. And I appreciate your time and consideration.
One other factual question. When the police got to the bottom of the stairs, were some of the doors open?
Their testimony, I think that was that some of them were at least partially open. I don't know that they said that they were all the way open. I don't remember specifically, but I believe that at least a couple of the doors were at least partially ajar to some extent in their testimony.
Any further questions, Justice Desmond or Justice Hirschfang?
No, thank you.
No.
Thank you, counsel. We will now hear from counsel for the Commonwealth.
Good morning, Your Honor, and may it please the court. Aaron Stoudinger, Assistant District Attorney for Middlesex County on behalf of the Commonwealth. And as was stated, the officers are allowed to enter into a dwelling pursuant to an arrest warrant where they have a reasonable belief that the residence is the arrestee's residence and that the arrestee is present at that time. I think beginning right where Justice Desmond's questioning left off, I do think it is implicit in the factual record established or the testimony at the motion to suppress hearing that the officers were told either by the victim at some point in time that the defendant lived and resided in the basement apartment at 9 Palmer Street. I think the officers' actions speak to having that explicit knowledge. When they arrive at the apartment, one officer immediately secures the back door that supposedly leads down into the basement. The other officer gains entry into the first floor common area, immediately asks the tenant who lets him into the building where the basement is. And I think from this, it's reasonable to infer that implicit in the holding, in the denial of the motion to suppress, is a finding that the victim told them or the officers from some source had explicit knowledge that it was the basement apartment that the defendant resided in.
So let's assume that that's true. Then how was it clearly the officers didn't know which room? You agree with that?
Yes, I believe there was some testimony that they were unsure of the layout of the basement apartment.
Right. And so at the time when the music's going up and down, they're still not sure. They may think he's in there, but they're still not sure, right?
Correct, Your Honor.
Okay. And then at some point he texts her and he tells her that I'm at some other location. I forget exactly where, if it was the square or some other location in town or someplace, I believe. And they actually went and they looked there, right?
Correct. Yeah.
They went and they looked there because, well, now they had reason to believe that maybe he was there and he wasn't in the apartment, right?
Correct. But I don't believe, sorry.
How do we jump from there to when they didn't find him there? Well, that must have been a ruse, and so we know he's inside.
Yes, Your Honor, and I believe that the defendant's attempts to mislead officers and kind of bring them away from the apartment doesn't necessarily diminish their reasonable belief that had previously been established based on the victim's statement that when she was leaving the apartment, when she was heading away from the apartment, she saw the defendant head back towards the apartment. The officers then, they respond to the victim at around 1:55 a.m. And after securing the victim, they immediately go back to the apartment. And I think they establish a perimeter around the building at around 2 a.m. to 10 a.m. One of the officers testified to. And I think this quick response, this immediate response by the officers gives at least the reasonable belief that if he was heading back to the apartment, as the victim had stated to officers, that he wouldn't have been able to escape or leave to go to a different location. And therefore, when the officers go to search the areas that the defendant says he's at, and there's nobody there, they can't locate the defendant, it's reasonable for them to believe that the person who's shuffling inside, the person who's not responding to their calls down, the officers announce their presence and ask for the defendant by name. And the fact that there's no response, but there's clearly somebody moving around in the apartment, I think those facts give rise to a reasonable belief that the person, whoever it is shuffling around in this basement, is the defendant.
Mr. Stoudinger, let me ask you a more fundamental question. I didn't see a copy of the motion to suppress, supporting memorandum, supporting affidavit in the record appendix or in the appellate record before us. Am I missing something, or am I correct that it was not provided?
It was not in the record appendix. I don't know if the motion was simply made orally or not, but the motion was not included in the record appendix.
So having read the transcript of the motion to suppress hearing and looking at the defendant's closing argument, he seemed to be arguing that it was practical for the police to apply for a search warrant, and they didn't do so, and there wasn't enough particularity to conduct this search, if you will. I'm not sure that that's the same argument that's being made on appeal. So I guess that reverts to my question, which is, without the motion to suppress and the accompanying memorandum and affidavit, how do we know what was before the trial judge? I mean, we can't review something that wasn't placed before the judge on a motion to suppress.
Correct, Your Honor. And I do believe there was some below, at least it appeared from the motion to suppress hearing, that there was some question as to whether the officers had the authority to enter the residence pursuant to default warrants. I think the defendant was suggesting that these were simply default warrants, and that was why they would have been required to go get an additional search warrant. I don't believe that the defendant challenges that the validity of the arrest warrants on appeal. And so I believe what we have is what was before, is what we can see from the motion to suppress testimony was just a challenge to the reasonableness of the dwelling being the defendant's residence and the reasonable belief of him being present at the time of entry.
So that is indeed different than what was the motion before the court at the hearing stage, right? Because the focus was on, does a default warrant have the same force and effect as an arrest warrant? Did they know how to get before a magistrate after hours? There was a lot of questioning in that regard about whether or not they needed to wait. They had the house secured with the perimeter, and should they have waited before they entered?
Yeah, and that was a line of questioning at the motion to suppress, but I do think that the ability of the officers to enter pursuant to an arrest warrant is without question. So I don't think that's challenged here. The motion to suppress also focused on the reasonableness of the officer's belief. So I don't think the validity of the arrest warrants is before this court. If that answers your question, sorry, Your Honor.
It doesn't for me. I mean, again, I'm trying to figure out whether or not the argument that's being made on appeal, this specific argument was raised and made before the motion judge. And I'm seeing more of a distinction than a similarity, but I assure you we will reread the transcript and the information before us again.
Here, the focus seems to be the scope of the search, which I don't think was the focus at the hearing. Would you agree with that?
Correct, yes. Or not the scope, but the reasonableness of the officer's belief, which wasn't necessarily the focus at the motion to suppress hearing. But I do believe there was some questioning, maybe tangentially, regarding the officer's belief. And additionally, I would just emphasize it. You guys had, the justices had asked regarding the distinction between the top of the stairs and the basement apartment. And I think one of the key facts that was from the motion to suppress hearing was that there wasn't any external indicia of multiple apartments. So if the officers are standing at the top of the stairs and they have a reasonable belief that the defendant is present in the basement apartment, one officer states that he's looking down the stairs with a sharp right. He can't see into the basement. The other officer is at an external door, looking at a solid wood door. And I think it's important to note that there wasn't any evidence of multiple mailboxes, of different nameplates. Even when the officers enter the basement apartment, the doors don't have different, there's no evidence that the doors have different numbering or separate locks or different nameplates, any sort of thing that you would expect to see in a rooming house with multiple rooms. From all the evidence that was presented at the motion to suppress hearing, this was one basement apartment with multiple rooms. As you noted, even when they got down into the basement, the doors, two of the doors were ajar. And in fact, the room in which the defendant was found, that door had been open. I think this is just further evidence that this basement apartment was either treated as a single apartment with multiple rooms, or even if it was a rooming house with common area, the hallway would have been a common area and the door was open. I think in any case, the officers have a reasonable belief that either that this is one basement apartment, and the absence of any evidence suggesting otherwise does not change the reasonableness of that belief, even when they get down into the basement apartment.
And they found him hiding in a closet?
Correct.
And you say that even if we suppress the photographs and the observations that were made in plain view, you still have a strong case. And so it wasn't prejudicial.
Yes, Your Honor. Even if the photographs and of the bloody pillow and the paper towel were suppressed, I do think any error was harmless beyond a reasonable doubt. The victim gave direct testimony of her injuries at trial. The officers gave direct testimony that they witnessed the injuries of the defendant. They described her as with dried blood on her. The victim testified that she had been kicked, that she had been thrown. Photographs of the defendant's injuries were admitted and are not challenged. Of her injuries were admitted and are not challenged here. The victim's medical records were admitted and weren't challenged here. I think there was more than enough evidence to support a finding that she had been, the conviction for that she had been assaulted. And any of these photographs were merely cumulative of otherwise already overwhelming evidence.
I'm intrigued by, and it may be just that I'm intrigued by it and that it actually has no legal relevance to this case, so don't let me lead you astray, but I'm intrigued by the notion that the officers went downstairs to conduct a protective sweep before presumably looking for the defendant and effectuating an arrest, and that they went into a closed closet. So, I mean, if the notion of a protective sweep is, we're going to let a dog loose down here, we want to make sure there's not going to be some, gruesome outcome from some person that we don't know is there, why is it reasonable to go into a space in which presumably if there was a person, that person would be safe from the dog?
Your Honor, I don't think that the officers are required in their protective sweep to be restricted just based on their belief that based on their stated belief that they didn't want the dog to injure people. I think they were allowed to go down and secure the space pursuant to a protective sweep, and that entails the closet. I don't think that they're restricted to just places that the dog could reach. Once they have the ability to go down and conduct the protective sweep, that involves the entire area.
So the plan would be to go down with the dog, open any closed doors, including the doors to these other rooms, if they were indeed other units, and any closed doors within those rooms.
I believe so. I believe they would be permitted to do so under the protective sweep.
What were the underlying charges for the arrest warrants?
I do not know if the record established what the underlying charges were. I do remember that one of the officers testified that they had been made aware that one of the warrants was for a prior domestic and violent incident, but I don't remember if there was direct testimony as to the exact charges, just that they knew that one of them had been for a prior violent assault.
So, I mean, but there's a difference, right, between cases, for example, in which the underlying crime is assault and battery by means of a dangerous weapon to wit a firearm, and the arrest warrant is for OUI, let's say. I mean, the reasonableness of the officer's actions in conducting a sweep should be proportionate to the circumstances known to all of the circumstances known to the officer, including a defendant's prior record, right?
Correct, Your Honor. And that's why I do think it is important that they had the information that this had been a prior violent crime that he had an outstanding warrant for. Like you said, it is different in kind from just an OUI. And so they could have a reasonable belief that a protective sweep was necessary to protect either themselves or, as the officer stated, others that may have been in the apartment.
Wasn't there some evidence elicited at the motion hearing that they were familiar or somewhat familiar with his history, his Corey, and that he had a record of violent crimes?
Correct, Your Honor, but it's unclear from the motion to suppress hearing when they received that that message from dispatch. They did receive a message regarding his Corey and his previous violent crimes, but there was a suggestion that it might have been after they had already entered. It's just the testimony at the suppression hearing was not clear as to when they received that message, but they did have knowledge that he had a long history of violent crimes, or what I believe what they described as a long.
Let me check. Any further questions, Justice Desmond or Justice Hirschfang?
No, thank you.
Seeing none,
Thank you.
I'd like to thank